May it please the court, I'm Mark Ayers for Encompass Health Rehabilitation Hospital of Largo. Your Honor, I'd like to reserve 5 minutes. This petition for a certiorari presents the often litigated issue of whether an action brought in ordinary negligence is truly an action that sounds in medical malpractice. The issue here is quite straightforward. There's no real dispute about the applicable law. And everything that's obviously crucial in these types of cases, as this court said in McManus.
Does every patient get a bed alarm?
I'm sorry,
Does every patient automatically get a bed alarm?
I don't know the answer.
Who made the decision to utilize the bed alarm in this case?
That's not in the, it's not in the pleadings.
Okay.
And that's kind of the crucial point is that this determination at the outset of is this a medical malpractice action or is it an ordinary negligence action? As I was saying, as the court mentioned in McManus, citing the Towns case from the Florida Supreme Court, is strictly limited to the 4 corners of the complaint. That's what we have. And that's exactly where I want to turn because these are extremely helpful and clear. First of all, it's clear from paragraph 3 of the complaint that, and it's not disputed, that the hospital is a healthcare provider under the Medical Malpractice Act, Chapter 766. It's also clear from paragraph 6 that Mrs. Shoemaker was there to receive medical rehabilitation care and services. That's why she was there. And it's further clear from paragraph 8 of the complaint that the bed alarm was provided as a part of that medical care and service. In fact, paragraph 8 says this: Encompass uses a bed alarm to provide an alert to Encompass's staff members should Arlene Shoemaker attempt to or unsuccessfully rise from her bed and attempt to walk without assistance. And so the question here is whether plaintiff's allegations, the core allegations, that the hospital staff failed to properly maintain and utilize the hospital bed alarm is, quote, directly related to medical care and services. Specifically, the allegations are these, and it's just repeated 3 times in the complaint. Whether the hospital was, quote, negligent and failed to use reasonable care by failing to ensure that the bed alarm was properly functioning. That word properly is important. And or by failing to, quote, properly activate the alarm. I mean, on its face, this implicates, when you say, well, was the bed properly, did you ensure that the bed alarm was properly functioning? Implicates, all right, well, there's obviously some procedure that the nursing staff, who would presumably be the ones installing the bed alarm, are supposed to follow to properly determine whether the bed alarm is functioning and to properly activate the alarm. This is not a case where a bed alarm is ordered and not done or something like that. It's just, well, we don't think that this was properly insured. I mean, I would ask the question, how does one ensure that a hospital bed alarm is properly functioning? I think if you ask 10 people on the street, they'd say, I don't know, that sounds like something that nurses do or that are trained for. And so when it's looked just at the 4 corners of the complaint, this sounds in a claim that is directly related to the medical care and services that she was receiving.
And forgive me if I'm wrong, didn't the complaint allege, maybe I just read it somewhere else, that the light part of the alarm went off, but the sound part or the notification part didn't?
Yeah, the complaint actually alleges 3 different things. They all say that the sound did not go off. Right. They are, I guess, getting these from, they're not attached, but from some materials that they've seen, that they all say that the sound didn't go off. So one says that the light went off.
I bring that up as what I suspect on the other side going to respond to your hypothetical, which is to say, no, you don't need a nurse to fit and listen if the sound goes off or not. And that's something anybody can do. And that's if you focus just strictly on the mechanical operation or what everybody can see the way this thing is supposed to work, there's no medical part to it. It's just, does this alarm work or does it?
But we don't know that the alarm works until something happens. I mean, that's the question. The question is, and what's alleged is, was it and I'll read it again, failing to ensure the bed alarm was properly functioning. That's something that you're doing at the outset. When I'm setting up the bed,
What if we've got a patient here who is in the facility for 10 days? And I don't think the complaint specifies whether the alarm was used beginning on the first day or if it was subsequently put in. But the hypothetical I'm going towards is assume for the sake of argument that the alarm was fully operational when it was installed. But at some point the batteries die, or maybe there's a separate battery for the light versus the sound. You know, we don't know that. But would it still be in your opinion, a medical malpractice claim if the alarm was properly installed, was properly working, and then the battery died and somebody didn't catch it the day it died?
if the complaint still reads like this, it would have to be considered a medical malpractice.
So the fact that a doctor or someone made a medical determination that this patient needed a bed alarm and one was provided, but for some reason it later fails, that's always going to be a medical malpractice claim.
Well, against the hospital, if we're talking about you failed to follow the procedures to ensure that that it was properly maintained, just like any other piece of equipment that would be there. That would be, well, you fell below the standard of care to determine whether this was maintained, just like in this court's Corbo decision, where the person is hooked up to the electric, maybe some kind of TENS unit or something like that, and the allegation was it properly maintained? It ended up burning the person's arm.
The cases talk about some of these types of situations fall within a gray area, maybe negligence, maybe medical malpractice negligence. Is there anything that would preclude your client from later seeking a dismissal if discovery revealed this alarm didn't work from the day it was installed, or it wasn't installed until the day she fell and nobody checked to see if it was operational?
Well, as this court has made clear, and as other courts have in these types of cases, if they've determined that, all right, at least as pleaded here, we're going to lean on the side of saying that it's ordinary negligence, and oftentimes you'll see at the bottom. However, if as the case develops, it turns out that you really are attacking the standard of care, they can certainly bring that up. And so if we're in that situation, then yes, we would be able to bring it up. Let's say if the case further develops, then yes, we can bring it up to summary judgment stage or whatever. But here we have to say, well, but what are we dealing with right here? Here we're dealing with just the four corners of the complaint. There is a standard that says, and McManus talks about this, that any doubts are to be resolved in favor of the plaintiff's claim, being an ordinary negligence claim. The issue there, though, is that doubt can't be created by attorney argument. Any doubt that that's referring to is some kind of, if you think about like an inherent.
Can we look at this complaint and see that this woman was in the hospital or in the facility for 10 days? There is nothing in the allegations that suggests it didn't work from the get-go. So somewhere in there, it's possible that it failed. Is the evidence sufficiently, not the evidence, but are the allegations sufficiently concrete to say there is no way this can be general ordinary negligence?
As pleaded currently, yes, because when I read this allegation, failing to use reasonable care to ensure that the bed alarm was properly functioning and or failing to properly activate the alarm, that is directly implicating what are the procedures here that we are to use to properly install and maintain this machine.
Listening to me if she fell on the first day. And we don't know if the alarm was installed the first day. Maybe it was, maybe it wasn't. But I'm troubled by concluding that the trial court got it wrong when this case has not been adequately developed to flesh out some of these issues. You may have evidence, you may be able to provide evidence that says this alarm was never installed properly or was installed properly, wasn't working at the beginning or was working at the beginning. I mean, I'm concerned when the standard is, it's a gray area. It seems to me like a gray area type of case. And it seems to me that if we read the most favorably to the plaintiff, which the law says you're supposed to, why this doesn't go a little bit further to conclusively establish is it a med mal case or an ordinary negligence case?
Well, I would say that every part that we heard from the opposition, from the plaintiff, when this case was argued below and here on petition, has been, oh, the bed alarm it don't work. That's a really simple device, and everybody, the people of ordinary negligence or ordinary common experience would know how to operate this. None of those facts. Well, they're not facts, but none of those allegations.
Discover some facts that show, or they might discover some facts that show the doctor came in that morning, checked the alarm, it wasn't working, entered an order saying alarm needs to be replaced. And if that didn't happen, it seems like that would be a stronger case for medical malpractice for not following through on the doctor's order. But again, my concern is I'm not sure, based on the four corners of the complaint, that I can say convincingly that this has to be a medical malpractice case.
I think what I would say, Your Honor, in response is it's just when examining that language that they use, it's difficult to know how to read that without implicating here's how the nursing staff, assuming it was a nursing staff to put this on, is supposed to do this. I mean, these types of devices, monitoring devices and so forth, are precisely the types of things that you would be trained for specifically. They're not the type of thing.
You don't know that without, we just don't know that without discovery a little bit further. And what troubles me is the way you're articulating this and framing this, which is the only way we can get into this is to ask the question, what are the procedures? What are the procedures could just as easily be applied to if she had slipped and fallen on a transient substance in her room that was somebody's responsibility to eyeball and see and flag, and that didn't happen. No one would think, I mean, I don't think, you wouldn't suggest that if there was some, apple juice that had been left on her floor and she got out of bed and slipped on that's not a medical negligence.
No, in fact, there's cases like that that make it very clear that just because you're in a hospital doesn't mean that everything that happens to you. What I would say there, though, is,
And even though there may very well be a procedure that RNs and LPNs are supposed to employ when they go into rooms to scan and make sure there's no obvious places for the patient to fall. Even that procedure would make this a medical negligence case, or would it?
well, the big difference there is the water on the floor is not something that has been directed for that person's care. That's something that's now on the floor. But this device,
The other side of that, but the procedure would be in place, would be for the patient's care, for the patient's health, for the patient's safety. Right? Why else would you do a sweep check of the floor around the in the hallways, patient's area? It really comes down to the nature of how the thing operates and what level of medical knowledge and care goes into it. And Judge Silverman said, when you have something like this without just working with a complaint, it does seem to be to fall in the kind of gray area.
but I think the plaintiff is the master of the complaint. And if you're going to bring an action and you're going to sue a hospital based on, I mean, you look at what they say, it's like, it's very clear. She's there to receive medical care and services. They use bed alarms for medical care and services as part of this. If that's going to be the claim, then when you say, well, she was injured directly because of your failure to properly ensure that this medical device was set up and properly maintained. If that's,
It would be a different case if she had been assigned to a bed without a bed alarm at all. And beds with bed alarms were available, and the argument was, hey, given her condition, she should have been in the bed with a bed alarm and wasn't given one. That to me would be a little bit clearer that, hey, those kind of allegations, that sounds more along the lines of medical negligence. But the fact that the thing didn't make a sound when it should have, but did make a light flash. And so,
well, as far as what is, I mean, the only thing I can say to that is the Supreme Court has been very clear that we have to go by what is in the four corners of the complaint. We can't bring in concepts that were brought in below and then brought in the briefing about how this is very simple and so forth. None of that is in the pleadings. All we have is what was pleaded. And of course, the purposes of the Medical Malpractice Act and those pre-suit requirements, that's really what's at stake here. There's a reason why we have to make this threshold determination and put the burden on the plaintiff who actually is like, yes, you have some doubts that are resolved in your favor. You can't raise doubts just through your argument.
That's an interesting point. What field of expertise is the plaintiff supposed to find somebody on, what, like bed alarms or what?
I would think that installation and proper maintenance of hospital bed alarms would be something that nurses would be trained on when they set up hospital rooms. I mean, I would think that would be right in there. Obviously, there's nothing about that in the complaint. But
You're at your 5-minute mark if you wish to reserve the right.
thank you, Your Honor, I will.
May it please the court, I'm Brandon Vesley from the Florida Appellate Firm. I'm here on behalf of Richard Shoemaker, his personal representative of the estate of Arlene Shoemaker, and trial counsel Wes Smith is here in the courtroom as well. Your Honors, I think it's important to recognize that counsel didn't quite state the inquiry correctly. What Towns said, Supreme Court said, for a claim to sound in medical malpractice, the act from which the claim arises must be directly related to medical care or services. He talked about that. But it's which require the use of professional skill or judgment. And there's nothing in the four corners of this complaint to indicate that in order to turn on a bed alarm, in order to activate a bed alarm, or in order to make sure that the bed alarm works, you need professional skill or judgment. This is not something that, well, we liken this to turning on any device. And the question really is whether a juror could, from common experience, know what's involved in flipping a switch. And that's really what we have here. So we asked the court to look at the Towns case. We also asked the court to look at McManus. The common experience to evaluate the allegedly negligent act that McManus talked about is very apt here. And the courts are correct. You know, this case got off the bat. It was filed on February 10, 2022. And by March 11th, we had a motion to dismiss. So discovery was a small bit of some interrogatories. There was really no discovery in this case. And those interrogatories couldn't respond to the question of what exactly happened. So the court can, you know, that it was not part of the what's been presented in the appendix, but you know, it was 1 month before the motion to dismiss was filed. So we didn't really have a chance to explore the issue any greater, and neither did they. So you're right. You know, there is going to be a point in time if they're able to discover that there's some kind of medical influence on this case, there's some judgment or skill that's been used or failed to use, that they could bring some type of a motion for summary judgment. But at this point, under the four corners of this complaint, that is not an issue before this court. The issue was whether or not, well, we know that the order was in place. That's clear from the complaint, that she have a bed alarm on her bed. And we know that it did light up. So it was somehow activated, but the alarm part wasn't activated. The sound wasn't activated. So, Your Honors, to the extent that it possibly could have been, you know, because it wasn't turned on, or was it because it wasn't properly maintained? Those are issues of negligence, ordinary negligence, not medical malpractice, not the way it's been played in this case. So,
To go to the question that Judge Lucas raised earlier, if there is a procedure that nurses and other personnel are supposed to follow to make certain on a daily basis that the bed alarm is functioning, and if that procedure were not followed, would that turn it into a medical malpractice case?
you would have to look at the specific facts of that procedure. Is that procedure a medical procedure, or is it something that any human being can be trained to do?
If it is a nurse's duty, and I don't know in this case if it is or isn't, but for the purposes of discussion, if the procedures that the hospital or the facility have in place require a daily check to make certain that the equipment is fully operational. If there's a failure to follow that procedure and make that determination, would that make it a medical malpractice case? Would it make it closer to a medical malpractice case? Or is your position that's still ordinary negligence?
Nurses do all kinds of things in the hospital. Not everything that they do is the rendering of medical care. And the question is whether it's professional skill or judgment that is needed for them to determine whether this bed alarm is working properly.
So it sounds like your answer is, if there's a procedure that the alarm is to be checked by the daily nurse, morning nurse coming in and make sure it's working, or the night nurse making sure it works, your position is, doesn't matter if somebody else can push a button. If you fail to follow that procedure, it's not going to be in any way, shape, or form medical negligence. Is that what you're telling me?
I'm telling you, it would have to be determined.
Gray area.
Yeah, it's a gray area, Your Honor. Here's the thing, when a nurse comes to work in her station, does she flip the light switch? And if she flips the light switch, turn the lights on in the facility, is that something that requires medical professional skill or judgment? It doesn't. So they do things that are not necessarily rendering medical services or rendering medical aid.
So if there
You
is
have
a
to look-
specific procedure that a medical care provider is supposed to follow and does not, your position is, doesn't matter, anybody could have checked that alarm. That's what you're telling me.
That's what I'm telling you. Further discovery in this case may prove differently, but that's what I'm telling you based on the four corners of our complaint. And that's the information that we have before us at this point.
You all have not alleged in your complaint, unlike what the plaintiff apparently did in the Brown case in the fourth DCA, you all have not alleged that there was a procedure that wasn't followed or that there should have been a procedure. Have you?
Let me check.
That was-
I don't think so.
That seemed to me to be what was in play in Brown, it seemed to give the fourth DCA the basis for its ruling.
Where it ended up saying the adequacy of the hospital procedures depends on the prevailing professional standard for managing and supervising those admitted to emergency rooms. And the investigation provided other rendering of better medical care services.
And in that case, at least according to the opinion, it does appear that the plaintiff had positively alleged that there were procedures that weren't followed, or the procedures themselves were insufficient.
That specific allegation wasn't made, but we did allege that the bed alarm was placed there for a reason. And so there was some medical determination that she needed a bed alarm. The fact that it wasn't working properly, or the fact that somebody forgot to flip the switch, is not that's we've gone past the medical decision. The medical decision that she needed a bed alarm, that the Compass put a bed alarm on her bed was done. And now it's a question of, whether that particular bed alarm was maintained properly.
Answer your question. It sounds like you're saying this case might be similar to a tainted turkey case. Doctor says, feed this person. While they feed him tainted turkey, they get food poisoning. That's not a medical decision. That requires professional judgment. It's bad food. It's food poisoning. It's not a medical malpractice case, even though it happened in the hospital.
That's correct. If the nurse was feeding him and he choked on it because she stuck too much in his mouth, that's medical malpractice. But the fact that the turkey itself was bad wouldn't be medical malpractice.
I don't see the distinction between the effect of the law alleged in the complaint and the turkey case.
And you go back to the Lawson case, which I was involved in at one point. The Lawson case, the directive was to make sure that this psychiatric patient is locked up in this facility and doesn't get out, because if she gets out, she's probably going to commit suicide. Well, and then somebody accidentally left their keys on the counter and she took them and got out. So they weren't treating her. It wasn't a medical decision to leave the keys on the counter. It was a mistake, ordinary negligence. This was a mistake. That's what our four corners of our complaint say. It was a mistake. Mistakes happen even in medical facilities. And as this court is quite aware, any doubt as Judge Silverman stated, any doubt is supposed to go towards the plaintiff. So we're asking the court to recognize that at most this is a gray area, at most. It's probably not even a gray area. It's probably clear that it's just a matter of making a simple, ordinary negligence mistake, and we need to prove that's what happened. And we're entitled to that. But if in the course of this case, if we get down the path and there's some other facts that come out that support the defendant's side, then they have the opportunity at that point to bring it up. So we're asking the court to affirm this order denying the motion to dismiss. We're deny the petition for a certiorari and leave it for another day.
Thank you, Mr.
Thank you.
The tainted turkey, I didn't know where, I've heard of spotted hog cake. Wait, is that the same? No, it's not. Just a few points. Of course, when I was stating what the standard is, talking about directed toward the provision of medical care and services, and he's right. There's a second part to that, and that is one that involves professional skill or judgment. But that's exactly what we're talking about here. When you make the allegations about failing to use reasonable care by failing to ensure that the bed alarm is properly functioning and properly activating the alarm, again, you're talking about hospital staff doing something that, for the provision of care that's undisputed, that's in their allegations for the provision of care to this individual. And so that's when you're talking about professional skill and judgment, it doesn't always have to be, well, you have to have, that you were talking about brain surgery here. You're just talking about what are the types of things that doctors do, that nurses do, that they're specifically trained to do, that the general public would not be. I don't know if anybody would know what a hospital bed alarm is. And if I was sitting on the jury wondering what a hospital bed alarm was, the person, before I knew anything about it, because we don't, I would say, well, I assume that's some kind of hospital monitoring device that they're going to have to tell us about. And I would be right. One of the issues that keeps coming up when they said, well, we liken this to a very simple device to turning on any device. But you can't do that. You can't liken that to you can't say anything about it other than what's in the allegations. There is nothing in there. There could have been, but there's nothing in there to say that all this, you're just talking about flipping on a switch. All they have to do is flip on the switch and everything turns on, and they just didn't flip that switch on. There's no skill or judgment. We can't liken it to anything. So even though the briefs and the underlying arguments below are replete with this sort of assumptions, that's exactly what we can't do. When it talks about gray areas, that's actually comes from that footnote in the Towns decision from the Supreme Court, talking about some of these fall cases, falling out of beds and so forth, or off tables. It talks about that gray area. All it's really emphasizing there is, well, you have to look at the particular facts and circumstances. And we have one case where someone's sitting on the operating table, or not the operating table, the examination table. Examination's over, doctors leave, they just get up and fall off. And that was determined not to be a medical malpractice situation. And that was an ordinary negligence. Whereas other circumstances, like the Perez case or the Brown case, where they said, well, you should have taken steps. There were things that you should have done to ensure that somebody would not fall off, to properly ensure that that these things wouldn't happen, and you didn't do it. That was a medical malpractice action. So the gray area is just the directive there from the Supreme Court in that footnote, which is technically dicta, but I don't have any problem with it, is you have to look at the particular facts and circumstances. We're not going to make a rule that says anytime somebody falls, it's either this or that, or it should be assumed. When we talk about, well, there's nothing here to indicate professional skill or judgment, I would say that's just not what the four corners of the complaint say. And courts have also made clear that you can't avoid, we discussed this in particular in the reply brief, again, getting back to the purposes of the Medical Malpractice Act is to avoid getting into litigation on what actually is a medical malpractice case. And the legislature made it very clear, we want these to have to follow this procedure for any number of policy reasons. But that's why they make it clear. They make it also clear that these have to be strictly complied with, these pre-suit requirements, and there are reasons for that. And the courts have made it clear that, stemming from that, that a plaintiff can't get around these by just creatively staying vague and then, trying to fill in gaps perhaps with argument and so forth. That can't be done. That's why there's this threshold determination just from the four corners of the complaint. And we would say that the allegations that they made, talking about a specific hospital device given to her to receive the rehabilitative care that they don't dispute she was there for, satisfies this and is in fact a medical malpractice action. So we would ask the court to grant the petition and direct the trial court to dismiss the case.
Thank you very much. Interesting case. We appreciate very much. That concludes the oral argument portion of the docket, and we are adjourned.
All rise. Thank you. Travel safely.